26 minutes going up to 6 o'clock. Thank you so much for joining us here nationwide at 5. I'm Cliff Hughes.
Good afternoon, listeners. I'm Ricardo Brooks. Good afternoon, Sir Cliff.
Good afternoon, Ricardo. And we can tell you that the Prime Minister is still on his feet in the Parliament. He's been announcing a raft of measures to accelerate the response and the recovery after Beryl. Response is to do with additional spending for cleaning up the country, $500 million to the National Solid Waste Management Authority, $800 million to the National Works Agency, grants to help people with repairing their homes, including the roofs, grants to help with the medium and small business sector. We're going to have more on that. The Prime Minister is still speaking in the House during the cover story. We'll tell you more on that. But we're going to begin, Ricardo.
With yesterday's Court of Appeal ruling, the court has ruled that Kensington Primary School breached the constitutional rights of a child when it denied her access to school because she wears her hair in dreadlocks. The ruling partly overturns a July 2020 ruling by the Constitutional Court, which found that none of the child's constitutional rights had been breached. And that ruling back in July 2020 had triggered widespread public outcry.
The then 5-year-old child was denied enrollment at the St. Catherine-based Kensington Primary School after the principal advised her parents that the school had a policy against the wearing of dreadlocks. The school's policy also banned the wearing of braids or beads. Kensington Primary told the child's parents that past experiences with poor grooming, which led to an outbreak of lice and fungus, was the justification for the ban on dreadlocks.
The family filed a suit alleging the school had breached the child's rights to freedom of expression, equitable and humane treatment by a public authority, among other grounds. The Constitutional Court dismissed the lawsuit and had upheld the school's actions against the child. On Monday, the Court of Appeal said the lower court ruling was wrong and flawed. President of the court, Justice Patrick Brooks, the outgoing president, declared that the school's policy against dreadlocks breached the child's rights to freedom of expression and equitable treatment by public authority.
Importantly, the appeal court said those breaches were not demonstrably justified in a free and democratic society. We're going to get reactions now from the lead attorney, King's Counsel Michael Hylton, who argued the case before the Court of Appeal, and the president of the Universal Negro Improvement Association and African Communities League, Stephen Golding. Good afternoon, gentlemen.
Good afternoon.
Good afternoon. Good afternoon, Cliff and Ricardo.
Afternoon, Cliff.
Good afternoon.
Afternoon, Phil.
Let me begin with you, Casey Hylton. Going forward, what's the significance of this verdict from the Court of Appeal?
But can I start by saying that the greatest significance is the result for this child? You realize that this happened when she was 5, and that was 6 years ago. So most of her life has been spent with this slur over her head. This thing about she's a risk of infestation and lice and fungus and outrageous. And that being removed, that being declared by our court to be unjustified, I think is my starting point of importance of this case.
Yes.
Just for this child. But putting on about my lawyer hat now, it's a really important decision for policy, for guidance, and I think this is not just our schools. I think there are schools and workplaces and various organizations that have policies that are rooted in past, I hesitate to say prejudices, but in a way that's what it is.
Yes, that's what it is.
That I hope this judgment erases and puts in the dustbin of history where they belong.
And Casey Hylton, there have been some who, since the court handed down its ruling, are saying, but won't this be a strike against order? Because now someone might say, I can turn up at school with my hair dyed pink or green or orange or blue, and that the Court of Appeal has permitted that kind of what they're calling disorder.
Okay. Yeah, I have heard that. But consider this. The court made the point that every right is subject to restrictions, and those restrictions are expressed in the broad expression in the Constitution about demonstrably justified. So there are many restrictions on freedom of expression. You of course as journalists live with that every day. But in this particular context, for example, schools have uniforms. So all students at this school must wear this uniform. And I think our court would say that's justified. That's part of the school's discipline and identity and so on. There's a reference in the judgment to behavior that is not disruptive.
Mm-hmm.
Don't cause distractions to other students. And I think a student who was to come to class with pink and green hair would be disruptive, would be a distraction. Mm-hmm. And it would seem to me that that would be something that a school could reasonably say you ought not to do. Not to prejudge a case, but
right.
It's not unlimited.
So in other words, you think the fears might be overblown?
I think so. Yeah. I think so because you can have a policy, and schools need discipline. Mm-hmm. Yeah? Schools need order, and schools need to have an environment that the students can focus on what they're there for. Mm-hmm. And dress and hairstyle and whatever can detract from that. But if you're going to have a policy against it, it must be a rational policy. It must be fairly applied and not be selective. And unjustifiable.
Stephen Golding, your reaction from your perspective where the UNIA and African Communities League?
Should have happened a long time ago, Cliff. So congratulations to these learned judges who have now seen the light. We have to be honest in evaluating the facts around, these inherited practices that have come down to us from colonial times. And I think what was even embarrassing was the justification given in the courts about John Joe and lice. I mean, we know where this is coming from decades and decades back. It's time Jamaican people fully know that the dread have no 40 legs in I'm head. That's not how it works. People with dreadlocks can wash and groom and care their hair just like anybody else and are no more susceptible to those things than people without dreadlocks. So that is the first victory because I'm so tired of hearing that excuse. The fact is, we have a lot of regulations that are anti-Afrocentricity that have prevented our people from embracing their true identity as Africans and celebrating their heritage as melanated people. I would love to know from these schools, what are their policies about skin bleaching? What are their policies about the straightening of the melanated hair, which hairdressers will tell you is damaging to the natural Afro curls and black hair? But they have had no policies about that. So where is this policy against the expression of Afrocentricity coming from? And the argument of now they can dye their hair pink and blue, absolutely ridiculous. As the attorney was saying, schools have uniformity. They can put in their handbook or in their policy if they're against hair dyeing for whatever reason. They always have to have a reason to justify these policies. And I'm simply saying the argument about Junjo and lice should have been thrown away a long time ago. There should be no reason why black students, particularly even black girls, shouldn't be allowed to braid their hair as a means of better upkeep and easier to manage while in school. And there's no reason why black children who want to grow their hair longer should be prevented from having dreadlocks. I mean, I know we have had schools who said you have to justify it on a religious basis, and we give thanks for the recognition for the Rastafari community, but that should not be the only justification. The base justification is that we are African people. We are melanated. Our hair grows a certain way because of our physiology, and we must have policies that embrace that and celebrate that, so we don't have children growing up with a subconscious defect known as white supremacy, and that's what these policies have been upholded for too long. So congratulations on this small victory.
And we are assessing that Court of Appeal ruling yesterday, which found that Kensington Primary breached the rights of a child by enforcing a policy against her, which essentially barred her from enrollment at the school because she wore hair in dreadlocks. We have with us King's Counsel Michael Hylton and President of the Universal Negro Improvement Association and the African Communities League, Stephen Golding. Casey Hylton, the argument about breaching the right to freedom of religion was not accepted by the Court of Appeal. And I wanted your assessment as to what that may mean or could mean as it applies to Rastafarians.
I'm glad you went there, because I was going to pick up on something important that Stephen said. So the school says this policy is in place because of the risk of lice and whatever. Then they conceded that had the parents said that the reason was because they were Rastafarians, it would have been okay, which is totally irrational. If your reason against locks and braids and beads, by the way, which is that there's a risk of lice infestation, then it can't matter what your religious reason is. It's a health problem that should be stopped. It just shows the lack of rationale. Now, the reason for the court's finding about religion, the claim based on freedom of religion not succeeding, is because the parents did not give that reason. They said, this is the way we do it here, this is our family tradition and style and practice, and they didn't plead religion at the start. They later did. And the court said, that's something you needed to do up front at the start. And so we decided on the freedom of expression ground, not the freedom of religion ground.
Were you go ahead.
Let me add one other thing. So the family are not Rastafarians, and they indicated they're taking the Nazarene vow. And there was an issue in the full court as to, is that a religion? The Court of Appeal said, we don't need to go there. We don't need to decide whether this is a religion or not. It wasn't pleaded by the family at the outset. So that's the basis on which the court didn't allow that ground. And so it's not at all a precedent for other people and other cases where people do rely on their religion.
Okay. Were you surprised at my words now, restrictive arguments advanced by the government? Because I think in at least one instance, the government tried to claim that a child does not have an inherent, my understanding, right to expression, that a child cannot express anything because they are a minor. Were you surprised that the government took that stance?
I was. Stepping back, I was surprised that the government fought this case at all and sought to defend that policy, because I really think it was an indefensible policy. But, and I'm not blaming the lawyers. Lawyers argue the cases that they're given to argue. The child's position argument was interesting, and this case is important for you get now into the kind of detail that the constitutional lawyers really like. Can a child claim a right to freedom of expression? And the government argued no, because especially a small child like this, the child would need to, they said, come and do an affidavit to the court to say, here's what I was trying to express by the hair, which, is kind of a nonsensical position to take, because a 5-year-old is obviously doing what their family does, what their parents do. And parents speak for children. A small child's parent has the jurisdiction and the right to come to the court and say, here's my child's right being abused. Because a small child can't do that. And if you don't allow parents or guardians to do that, it would mean that small children would never have their rights vindicated. Another important thing in the judgment.
Stephen Golding, what's been the reaction of your members and their families? Are people aware of it in the first place, the ruling that is, and what's been their reaction?
Well, it did make the papers, Cliff. It's on nationwide. How could they not know? Celebratory. It's been a thorn, I think, in the side of our educational system for a long time. We have been talking about, redirecting the narrative. We've been talking about decolonizing education. This is an important step. Speaking about child's right to self-expression, it goes way beyond self-expression. Our hair is a part of our experience here in the Americas, where our foreparents were forcibly brought and trafficked. Our schools should be teaching us our real history, and the fact that in places like Brazil and Venezuela and Colombia, African descendant people during the time of enslavement, and you can check this, used to use the hairstyle, particularly of the women, to communicate messages, secret messages with one another. The Quilombos in Brazil spoke a lot about how messages were passed through hairstyle to the freedom fighters in the bushes from the enslaved Africans on the plantations. I mean, if we teach a history like that, and we begin to understand how we fought to liberate ourselves, mind, body, and soul, and in this particular case, using our body, then how could we as a country of over 90 to 95% African descendant come up with policies that do not recognize that struggle and do not celebrate that victory? Right? That is a part of the problem in the educational system. We still on Jack and Jill went up the hill to fetch a pail of water. Instead of teaching these children their true history, their real history, a history of struggle, a history of resistance, a history of being victorious, right? And it doesn't just start with hair policies. And again, I want to raise this question. Do the schools have a policy about skin bleaching? Or are they afraid to institute such a policy on the grounds of the right to freedom of expression? Huh? Skin bleaching is a serious problem. Our Garvey Club at the Marcus Garvey Technical High School, as far back as 2009, had to run a big campaign for students against the effects and damage that skin bleaching does to black people, and the fact that we're still indulging in it. But yet I hear none of these schools coming up with a policy like that. Is it because at the time when some of these schools were founded, it was popular to advocate for black people to bleach their skin? It used to be advertised in the newspapers. Marcus Garvey himself 100 years ago ran a campaign against skin bleaching. Right? So this is a victory, but there's much more for us to accomplish, Cliff. And it goes well beyond just the matter of hairstyle. It is how we are teaching our children to know their true story, as opposed to the whitewash, hand-me-down, colonial narrative of Wilberforce and Granville Sharp.
And Casey Hylton, following up on that point, the Charter of Rights, an interesting piece of legislation. I wondered if you have any thoughts on how that piece of legislation could contribute to the kind of enlightenment and enforcement and respect for the rights of Jamaicans that Stephen Golding talks about.
Yeah, well, let me just first say what a fascinating exposition that was. I always learn a lot when I listen to Stephen Golding, and I must thank you for all that you've just said. Our charter is such an important document and has so much to offer and so much that protection and rights it recognizes and gives to our people. But the problem is people don't know, and sometimes when they know, they think it's too difficult to enforce. A lot of credit needs to go to Mrs. Virgo, it's on Mrs. Virgo, because a lot of people recognize wrong is being done and just let it slide. They won't let this slide. They went, got lawyer, pursued this case, and I need to also credit Isaac Buchanan, who took up this case and fought it from the start. That's what more people need to do. So, there are difficult cases. The charter is there, offers the rights, but you need to do it. Somebody needs to get up and fight the fight.
So more lawyers will start offering pro bono services then, because that's also a hurdle.
It is. And that is something, too, that we need to encourage and have more of. Absolutely.
Yeah.
But it's important case, important precedent. It's something that, I certainly agree with Mr. Golden's comments about the fight just starting.
Yes. For the board chairmen and women and board persons of schools and principals, yes? What would you suggest that they do now, Mr. Hylton?
Okay. First thing they need to do is to look at their policies. They need to look at the things that they now have in place and measure them against this ruling and against, I presume they're going to be getting advice from lawyers as to how this ruling affects other things that they may be doing, and consider what they need to change. And I'm sure there are many things that ought to be reconsidered.
Mm-hmm. Yeah. And the same thing for employers.
Thank you. Yes.
Okay.
Good point.
So you'll allow me to wear my Crocs? Freedom of expression.
No.
I'd like to express myself by wearing my Crocs.
No, not in the office.
Cliff, that's a very interesting angle to bring up, because we also have to talk about here policies in places like the JDF and the JCF. And I'm not trying to knock the whole issue of uniformity and discipline, but these are organizations that include African descendant women. And if they would like to grow their hair, why is it that they must cream their hair if they want to have long hair? Why do our policies enforce that? And again, I want to mention the fact that it is proven that the hot iron and the chemical cream is not good for us from a health basis. Why should the JCF have a policy that says the police women cannot have dreadlocks, or in the JDF for that matter? I know it said so at one point. I hope it has changed by now, but not to my knowledge.
Thank you very much. Stephen Golding, President of the Universal Negro Improvement Association and African Communities League, and King's Counsel, Michael Hylton. Thank you very much, gentlemen.
Thank you, gentlemen.
You're welcome. Good.
My pleasure.
Good.